Suppose you as a worker or an employee are unhappy with your employer. You feel exploited or underpaid or just simply undervalued. You aren't getting enough leaves as you should, or your salary isn't being paid on time, or maybe your workplace environment is unhygienic, or maybe you and a few others have been wrongfully dismissed. Causes like these would leave you to revolt, right? That's exactly what we will be covering today. The various forms of disputes workers resort to so that their voices can be heard by the management and also have their demands fulfilled, all covered under the Industrial Disputes Act 1947. There are mainly three types of disputes: strikes, lockout, and gherao. Now, strike is when you, along with a group of others who are employed in the same industry, cease work in a unified manner under a common understanding. There are various ways by which you can strike. You could simply sit at your workplace and have control over your facilities but refuse to work. This is the sit down or pen down strike. Or you could start working but do the work ridiculously slow, thus restricting the rate of output. This is called go slow strike. Or you could not work for a short period of time, say an hour or an entire day, called token protest strike. This in a way gives a signal of danger to employer if wrong practices aren't stopped. Finally, you could choose not to go to work and organize rallies and demonstrations against your employer, which is called stay away strike. However, for going on strikes, you need to follow certain regulations given by the government, failing which will lead to penalty. We will cover these regulations shortly. Now, lockout is actually the weapon of the employer. It's temporary suspension of work or closing a workplace as a response to your strike. Do not confuse this with layoff. But here's another weapon for you. Gherao is a Hindi term which literally means forming a human barricade against the managers in your workplace premise to intimidate them into accepting your demand. But you may not want to resort to this as it's illegal and can be psychologically disturbing for the management. You could rather resort to picketing, which is an act of placing workmen in front of the workplace premise with placards and banners so as to inform everybody about the strike. If done with no violence, this is legal. Now, coming to the regulations for strikes and lockout. Firstly, you need to give a notice to your employer and conciliation officer about your strike 6 weeks before going on strike. Following which, you are also not allowed to go on strike in case of conciliation proceedings are on and 7 days thereafter. Neither can you strike if arbitration or adjudication is on and 2 months thereafter, or if any settlement or award is in operation. Similar such restrictions apply for employers' right to lockout. However, there are various machineries available under this act to help settle your dispute. Hence, you may want to opt for those rather than revolting. We will cover those machineries in another video. For now, thanks for watching. Do like, share and subscribe.